Good afternoon and welcome. For those of you that don't know me, I'm Professor Jonathan Adler here at the Case Western Reserve University School of Law and also director of our Center for Business Law and Regulation. The center was founded in 2003 by a former colleague of mine, Professor Annie Morris, who's with us today, to help prepare future leaders to understand business issues facing entrepreneurs, business entities, and other clients, to sponsor legal, empirical, and interdisciplinary research on the role and impact of government in the regulation of business, and to foster public debate regarding the role of government in the regulation of businesses. And our programs range from public lectures like this to workshops, such as one that we're holding tomorrow, academic conferences, and speaker programs like the Lindsay Cowan Business Law Lecture, which we will be holding in March next spring. Commissioner Bill Kovacic of the Federal Trade Commission will be delivering this academic year's lecture, and announcements for that will go out shortly. Today, it's really a pleasure to be able to welcome our guest for this lecture, Susan Dudley. Susan recently became director of the newly created George Washington University Regulatory Studies Center, which is a part of the affiliated with the Trachtenberg School of Public Policy and Public Administration at George Washington University. This program will work to improve regulatory policy by raising awareness of regulations' effects through research, education, and outreach. But prior to her new appointment, as I think all of you know, she was what we usually refer to as the regulatory czar, or what has been referred to as the regulatory czar. And as I'm sure many of you are aware, czars are a bit in the news these days. This was a position, or a position that is known as Administrator of the Office of Information and Regulatory Affairs within the Office of Management and Budget within the White House. It's a Senate-confirmed, presidentially appointed position that effectively oversees the White House's efforts to monitor and direct executive branch regulations, ensure compliance with the Paperwork Reduction Act, as well as deal with some other statutory responsibilities relating to information and the like. Prior to being administrator at OIRA, she directed the Regulatory Studies Program at the Mercatus Center at George Mason University and taught at the George Mason University School of Law. She previously worked as an economist not only at OIRA, but at the Environmental Protection Agency and the Commodity Futures Trading Commission. She's authored more than 25 scholarly publications on a wide range of regulatory matters, and it's really my honor and pleasure to be able to welcome her to the law school today to give a talk on ensuring accountable government regulations. So since you didn't come here to hear me, without any further ado, I give you Susan Dudley.
Well, I like getting applause before I talk. That means, well, it can only go downhill from here, so maybe I shouldn't like it. There are more seats in the front if people want to come closer. Thank you, Jonathan. I've known Jonathan and admired his work for a long time, so I'm very happy to be here. And I've never been to Cleveland before, so it was fun flying in and having a pretty view over the lake, so I hope to see a little bit more of it. What I thought I would do is start by just giving you an overview of what regulation is and the regulatory process, the federal regulatory process, and then talk a little bit about my experiences. So starting with the very big picture, that the federal government has two basic ways of achieving policy goals, of diverting private resources to achieve these public goals. One of them is through taxation and subsequent spending on programs, and the other is through legislation and regulation. Now, the federal programs, these on-budget programs, are they're tracked through the fiscal budget. They have to be appropriated by Congress, so there's a lot of accountability and oversight of these on-budget programs. Regulatory programs, on the other hand, what we do with regulations is we direct private parties, we compel private parties to behave in ways that achieve the public goals. And that is, the benefits and the costs are much less transparent. You know, there are various estimates about what are the effects overall of regulation, what are the costs of regulation, whereas the fiscal budget, you can look at that budget document and you can know. Regulation is different, which to me is part of what makes it more interesting. It's when you talk about you know, when I say my specialty is regulation, at a cocktail party, you can see people's eyes will just glaze over. But the fact that you're all here, and maybe I should ask you why you're all here, but how many of you are here because you're in Professor Adler's class and you have to be? Nobody. So I should look at the camera then. You're all watching, so pay attention for the next hour for those who aren't. For CLE credits, are you here for that, or and other faculty? Well, so there's other people well, we'll have to talk afterwards and find out. So I'm obviously going to focus on the regulation aspect of achieving policy goals. We generally divide regulations into two categories: economic regulation and social regulation. The economic regulations are generally accomplished through the independent commissions, like the Federal Trade Commission, the Federal Energy Regulatory Commission, and they regulate price, quantity, quality, entry, exit, and often they're done through what is known as formal regulation or through adjudication. So these commissions serve, well, you're lawyers, so they adjudicate rather than through the notice and comment rulemaking. Social regulation tends to regulate health, safety, environmental regulation or matters, and that's done through informal rulemaking. Which, when I talk to my students about informal rulemaking, it sounds so formal and complex. They're surprised. That's the informal one, but that's the notice and comment rulemaking. This is a chart that I think is an interesting graph. And it tells an interesting story, but it's really not the whole story. If you look at this, you can see that this is the number of Federal Register pages that are published each year. And you can see that it's been increasing, and that in particular in the 1970s, there in the mid-1970s, we saw that increased growth in Federal Register pages. The reason I think that it's not the whole story is at about that same time, we actually were seeing a decline in economic regulation. So economic regulations were the traditional regulations, or the traditional type of regulation starting in the 1880s through the New Deal. We saw the Interstate Commerce Commission, we saw trucking, surface transportation, and then airlines and natural gas. In about the 1970s, there were, I think it started with academic research that showed that indeed it seemed that these regulations that we had put in place to protect consumers were actually benefiting the regulated parties more than they were benefiting consumers. And so the combination of this academic research that kind of shed some light on that and some policy entrepreneurs in Washington. In fact, I'm going to be interviewing some of them as part of my new program. We actually saw a decline in economic regulation in the 1970s. So Jimmy Carter, in fact, when my website gets up, it's going to be regulatorystudies.gwu.edu. I just got that website today. So if you click on it, it won't take you anywhere but the main GW page. But soon it'll be up. And one of the first things I'm going to have on there is just a little a commentary about how Ted Kennedy was instrumental in that deregulation movement of the late 70s and early 80s. But so at the same time, so we saw the deregulation of that traditional economic type of regulation, but we saw an increase in the social regulation. And that, because you have to go through notice and comment, you produce more Federal Register pages. So that was the time when we saw the Environmental Protection Agency, the Occupational Safety and Health Administration, the Consumer Product Safety Commission. That's the beginning of that increase. I've got highlighted there, those red lines. That's the final year of the president's term. And we may have time to come back to that later, but right now I'll just tell you why I highlighted those. You can see there tend to be more regulations in that last year than in the other years. So OMB, as Jonathan said, I was in the Office of Management and Budget. People sometimes think, well, why, there's concern about OIRA, the Office of Information and Regulatory Affairs. We call OIRA. The staff, we call ourselves OIRAnians. And that office has, in fact, I'm kind of jumping ahead of my slides, but OIRA's role of overseeing regulations is similar to the role that OMB has for a lot of different parts of the government. So you have OMB oversees the budget. So individual agencies work with OMB to develop their budgets. They oversee the management. They want to assure that when we're doing these programs, we're getting results, the performance and the results. All legislation. When there's an administration position on legislation, that goes through OMB, and OMB coordinates with all the other agencies that might have an interest in that legislation. Any testimony by an administration official has to get cleared through OMB. And then finally, regulation, as Jonathan said, information collection, statistical policy, and that also gets coordinated from OMB. And that's the part, of course, that I find so interesting, and that's the office that I headed for the last couple years. The Office of Information and Regulatory Affairs was created in 1980 by the Paperwork Reduction Act. But every president since Nixon had a role for the Executive Office of the President for overseeing regulations. And it evolved. So in OIRA was created by the PRA. When President Reagan came in, he also issued an executive order that gave OIRA the authority not just to review paperwork to make sure that I'm going to forget the exact phrase, but that citizens weren't overly burdened with paperwork, and that there was a balancing the need for the information and the burden that it imposed. He also gave that new office the responsibility for reviewing regulations and making sure that they provide net benefits to society. And the people who didn't, several of the people who didn't raise their hands when I asked who people were at the beginning are some people who actually know a lot more about this area than I do. And I may mention each of them as I go through today, but one is Brian Mannix, who was actually at, he was one of the very first people at OIRA in 1981. He'd been in Jimmy Carter's Council on Wage and Price Stability, and some of the economists that were in, and that was the office that reviewed regulations in different format, and then formed OIRA. They were part of the team that formed OIRA. So Brian could tell you a lot more about what OIRA was like in those days. I actually worked in OIRA after that. I was a latecomer arriving at the office in 1984. There are more dignitaries, but I think I'm going to mention them later. Then when President George H.W. Bush relied on the same executive order, same policies. When President Clinton came in, I'm trying to think of the right word, but he got rid of Executive Order 12291 and instead issued 12866, which, to the dismay of some people, was actually very similar to President Reagan's executive order. It changed some of the procedures, but it required that same evaluation of regulations. Let's make sure that it does more good than harm, this notion of meeting net benefits. Now, and then George W. Bush continued with that same executive order, which is still in place right now, although President Obama has signaled his intent to change it. And I'm going to talk about that a little bit later. So there's a question now is what will that oversight look like? Just quickly, because I think I'm already taking more time than I wanted to, let me just go through the regulatory process. Before a regulation can be issued, Congress has to delegate authority to regulatory agencies. So there has to be that authorizing legislation. And it can be very specific, or it can be very general. And a specific example was Congress last year said that pilots, the mandatory retirement age for pilots had to be 65 instead of 62. So I think something like that. That was one that FAA didn't really have a lot of wiggle room, because Congress said very specifically what that regulation should be. Whereas something like the Occupational Safety and Health Act is very vague. It talks about protecting workers in the workplace, and OSHA has a lot of flexibility to issue regulations under that. So agencies will take that legislation, they'll draft a proposal. That draft proposal has to come to OIRA for interagency review, and OIRA will review it using the criteria in the executive order and do a coordination with other agencies, send it to other agencies that may be interested, and coordinate that review. Then after that, it gets published in the Federal Register as a proposal for public comment. When public comment's done, the agency revises it to respond to those, and it has to, under the Administrative Procedure Act, they have to take into account those public comments. Something very different than in Europe. They find our administrative procedures very different. I mean, they talk about, they bring together stakeholders, but this notion of anybody in the public or anybody in other countries can file comments on our regulations they find curious. After making those revisions, it comes through OIRA for review again. So OIRA reviews both at the proposed stage and then the final stage. Then only after that, the regulation can be published. But it's still not over, because then under the Congressional Review Act, Congress can overturn it, although that is not likely to be used very much. If it wasn't used in the last few months, it probably won't be used. And then, of course, lawsuits, so judicial review. What is this criteria that OIRA applies and that Presidents Reagan through Clinton have required? There are several steps. One is, what is the problem we're trying to solve? Market failure is one. Why is it that people acting without government involvement can't solve that problem? Once you've answered that, well, is it appropriate for the federal government to be involved, or is this something that could better be handled at state and local levels? Could it better be handled through insurance or some other something other than federal regulation? Once you've answered that question, agencies are supposed to look at different alternatives. And then for those alternatives, look at the costs, the benefits, how effective will these different alternatives be? Taking into account how much information do we have that supports these different alternatives, and who's receiving the benefits and who's paying the costs. Looking at the distribution of those effects is something else that's part of the executive order. So that was my quick overview, and now I'm going to talk about several observations, I guess. One is, given OIRA's role there, you can imagine that OIRA is not always really popular with the agencies that we oversee. So my first question is, why is there no constituency? And you can say, well, just because they're not popular with the agencies doesn't mean there's no constituency. But I think I'll justify that in a minute. But let me just first start the question of, why do you think that would be? Economists have pointed out, and I think have brought together evidence that supports the fact that agencies do tend to shape their regulation to serve the interests of the parties most affected. So agencies will have they'll have a specific, they'll have a constituency. OIRA is supposed to step back and take this broad, cross-cutting look, and therefore there really is nobody that's looking out for that. Now, people will say, well, I can understand that in a Democratic administration, because Democrats, their constituency are environmental groups, worker safety, et cetera, and so I can understand that, but Republicans' constituency is businesses. And businesses must always want less regulation, so OIRA must be popular there. I can tell you my experience, and I think more than my experience, but the evidence is that's not true. Businesses also find that regulations can increase their competitive advantage. So it is there's really no particular group, there's no champion for careful scrutiny of regulation to make sure that on net it provides net benefits. And as a little bit of evidence, my own personal experience is that Jonathan pointed out that this is a presidential appointment, Senate confirmed. I was not Senate confirmed. I'm going to forget the dates, but I think I had my first interview in the fall of 2006. I was told that I was going to be the nominee in the March of 2007. My name was sent to the Senate in July of 2007. By April 2000, wait, have I got these dates wrong? I have. Move all that back a year. So I was nominated in July 2006. April 2007, I still didn't have a vote. The Senate hadn't voted on my confirmation. So I was a recess appointment. I was, during the April recess, I was put in the position. Another of our dignitaries here is Vanderbilt professor Jim Blumenthal, who was the nominee in the George H.W. Bush administration, never confirmed. In fact, no one was ever confirmed during the entire 4 years of the first Bush administration. In fact, I went back and looked, and since the requirement that OIRA be confirmed, 1/3 of the time it has been without an administrator. And in fact, Cass Sunstein, who is Obama's appointee, he was confirmed 2 weeks ago, but he too faced criticism from both sides of the aisle. Republicans were concerned about his animal rights writings and the fact that he was a czar. You know, he got caught up in this whole anti-czar or objection to czars. Democrats were concerned that he actually, and I'm sort of putting words in their mouth, that he believed in the function of the office. He believes in analysis. He believes in cost-benefit analysis. He believes in this oversight. So there was no champion. So you might think it was just me, but Cass, who is a very respected scholar, also didn't have any champions for him. And I want to talk about czars, but I think maybe I'll wait a little bit. So I don't have my notes out, which means I'm probably just stumbling around. Okay, the second question is Rufus Miles. Who knows who Rufus Miles was, or what he's famous for saying? You've heard his phrase, "Where you stand depends on where you sit." And he, as it turns out, was an alumnus of the Bureau of the Budget, which was OMB's predecessor. And so was he right? I think he was right. I think that the OIRA staff are, the best and the brightest. They come out of, they have law degrees, policy degrees, economic science degrees from good schools. They're very smart, and they are just very devoted to their mission of trying to understand what the consequences of regulations will be and what the effects of regulations will be. Now, agency staff are also very smart. But I think if you were to take the same bright young person out of a top law school or policy school or econ program, put them in an agency, they would behave very differently than that very same person who, if you put them in OIRA. Because where you stand depends on where you sit. And I have to look at my notes because I had something else very insightful to say about that. Okay, yes, I wanted to get back to OIRA's role. The president needs OIRA. The president has to be the ultimate arbiter of these. So if, for example, and I'll use Department of Homeland Security as an example, not because they're the only agencies, but they have a very specific mission to protect us from, let's see, I should get my glasses. Prevent and deter terrorist attacks and protect against and respond to threats and hazards to the nation. And they take that very seriously. They also are supposed to welcome lawful immigrants, visitors, and trade. That's clearly a secondary goal. And OIRA as a function, when there would be regulations that maybe would, but we'd say, gee, if you squeeze the balloon here, maybe something else, and something else will happen over here. OIRA bringing together the Commerce Department, the Justice Department, the Small Business Administration, bringing together the different groups to be able to bring about that broader perspective, that balancing perspective. That serves the president. The president needs to have a broader perspective, and I think OIRA is instrumental in doing that. And this is back to czars. I am also concerned about the number of narrow-focused appointments in the White House. But I think a czar is very different, and Cass Sunstein has been caught up in this czar concern. The OIRA administrator has to go through Senate confirmation. That means they can be called up to testify before Congress, and I was. Whereas the czars, if you're not accountable to anyone, so what they're doing is not transparent, not accountable, and they have a narrow focus. Whereas the OIRA administrator steps back and provides that broader focus. So I think Cass is the anti-czar. So I think it's important to have something like that in the White House, being able to provide the president that broad perspective, the checks and the balances. And one of the tools that we use, of course, is regulatory analysis, which also has come under scrutiny, particularly benefit cost analysis. I see regulatory analysis as broader than benefit cost, but benefit cost analysis in particular. And I'll paraphrase Winston Churchill here in saying that it's the worst. Benefit cost analysis is the worst type of analysis there is, except for all the alternatives. And I think it's here to stay. Now, while President Obama has signaled that he may change the details of the executive order, he has also said that he recognizes the value of that dispassionate and analytical second opinion on agency actions and the analysis that involves. And I think the fact that he's appointed someone who believes in that analysis means that we will continue to see it. Now, there are real challenges, constraints on doing good analysis. One is legislative barriers, because there are very few statutes that specifically say you need to analyze the consequences of this, and there are others that say you can't. So there are constraints in legislation. And when you do that, when you say, well, science is the decider, science can't decide. Science doesn't draw lines. Science provides information and is essential for making decisions, but it doesn't help you decide that this is the level of pollution you want, or this is, it doesn't draw a line. So it's actually a charade to pretend that science can do that. So by doing that, it's less transparent than something that lays out the analysis, like a regulatory impact analysis. Another problem I see is that there's often, we'll decide on what we want to do, and then we'll do an after-the-fact analysis that justifies it. No, analysis really ought to come first to really provide you the information to help you make that decision. And the third is that it's just plain hard to do. I mean, think about things like Homeland Security regulation. I think it is particularly hard to do, and I won't go into detail because I'm running over. So I think despite the problems, which I recognize, regulatory impact analysis is the best way to lay out in a transparent and accountable way all the different factors that go into the decision. So I think it's essential for good decision making and understanding as much as we can before we take action what the consequences are likely to be. I do feel strongly that regulatory analysis is more than just benefit cost analysis, because government intervention, no matter how much you do the analysis, no matter how well you plan it out, it can never be as dynamic or responsive to people's needs as market forces are at achieving people's preferences for things. And I'm going to mention Brian again. He coined the phrase the planner's paradox. And the planner's paradox is that planners, when we plan a solution, it always looks better. When we can plan something, it always looks better than the alternatives, because all the analysis and assumptions that went into our analysis are our own. we don't see the unseen, the things that we didn't plan for. So the planner's paradox is it's always better to intervene in private action. So it's always better to tell people to limit their choices, because when we limit their choices, we can make them better off on paper. Yeah. Okay. My next question is, should we harmonize regulations internationally? One of the fun parts, one of the more fun, I loved this job. I think the OIRA administrator job was the best job. It's the best job in Washington. It was fun. It was stressful and intense, but it was fun. But one of the most fun parts of it, and maybe less stressful parts, was the international oversight of regulatory issues. I was particularly involved with the Europeans. There, I think the OIRA role is important, just as it is elsewhere, because agencies will have their bilateral conversations with their counterparts in other countries. Again, bringing them together with other agencies, we found that when I would host these, it was called the High-Level Regulatory Cooperation Forum, that we actually learned from each other. Agencies would learn, that's how you do your enforcement agreements. And so there are real benefits to that. There is pressure to harmonize or to converge, is another phrase. And that was one that I resisted, because you can converge on bads. And there was an excellent editorial in the Wall Street Journal today that I would recommend to people that pointed out for financial regulation, if we do that, our regulators are getting together around the world and they want to agree on certain limits. But when we do that, we lose that diversity, the experimentation that we learn in different countries. If we all make the same mistake, that's a recipe for systematic failure or systemic failure. So I emphasize, let's coordinate, let's share information, particularly on things like consumer product safety. Sharing information can be very important so that we know what others are learning about dangers in products. But harmonizing on regulation, I think, is a problem. And then finally, let's go back to that slide that I showed with the increase in regulation. Why is regulation increasing? Because when I was there, I felt intense pressure to regulate. And I think there are a couple reasons. One is that crises demand a response. And regulations demonstrate that you're doing something, you're taking action. The actual outcome is less important because it's farther down the road, but by golly, we're doing something now. So it's more important because it shows that we're doing something. Also, there's the interest group pressure can be intense. And I think I've talked about this enough already, but it's this public choice notion that politicians owe the people who put them in their position of power. And so there is demand for those regulations. And, the conventional wisdom, as I said, is that Democrats will be doing regulations, will regulate more because their constituents would like more regulation. But as I said, that was not my experience. That when I was there, tobacco companies wanted pre-marketing approval of cigarettes. The toy companies and food companies wanted regulations to ensure that their products were safe. Energy companies supported cap and trade for greenhouse gas emissions. And so I'll mention another of our dignitaries here. Bruce Yandel coined the phrase, bootleggers and Baptists, the bootleggers and Baptist theory of regulation. And that is, and I'm probably not going to do justice to it, but I'm going to try. That he talks about the 19th, early 20th century South, where the Baptists would oppose liquor sales on Sundays for moral reasons. Meanwhile, the bootleggers would grease the skids by, and Bruce should shout out at me if I'm really butchering his beautiful theory, would grease the skids, the politicians, by paying the politicians to support legislation that would ban liquor sales on Sundays, because of course that would increase their revenues, the bootleggers' revenues. So you'd see these bootlegger and Baptist coalitions. And when I was in government, it was fun to be able to identify the different bootlegger and Baptist coalitions. So particularly when a regulation seems to have a public, if there's a public interest associated with the regulation, it's almost impossible for a politician to resist it. And now I'll think, maybe I should even go back to that slide that had my midnight regulations, the red lines. So the final year, in the final few months of an administration, the pressure to regulate is particularly intense. This midnight regulation phenomenon has been documented, and you can just see it by looking at this graph. And maybe I won't even, but the pressure there is even more intense. And I think it's in your readings, but one of the things that the Chief of Staff in the previous administration did was try to limit the number of regulations in that final few months. And with mixed success. The article that I have that's in there in the Engage article talks about the mixed success that we have. I think it was an important thing to do, but I can tell you that the pressure from my colleagues, the pressure from regulated entities was intense. I understand you're right not to issue too many regulations in your last few months, but please just issue this one. This one's the one that you should do. So I don't see, regulation is going to continue to be a very important policy tool. And we've got big challenges ahead. We've got financial markets, healthcare, global, multi-generational problems like climate change, protecting Americans from terrorism. So it's all the more important now more than ever to understand when government regulation is appropriate, when it's not, to be able to analyze and understand what are the likely consequences of those regulations. And we need the best and the brightest to actually get involved in public policy, go into work in the public, because we need to bring the best information we can to bear on these problems, because good intentions just aren't enough. We might pave the road to somewhere we don't want to go. All right.
We have about 20 minutes for questions. There are two students that have microphones, so if you, once you're recognized for a question, just please wait for the microphone to arrive so that folks that are watching on the webcast can hear the question as well. I'll take the liberty of I guess the prerogative of asking the first question, which you mentioned both, or you mentioned that the Chief of Staff in the Bush administration issued a memo trying to reduce midnight regulations. And I guess my one question would be, and I understand why you would oppose midnight regulations, because as an academic, prior to being in the administration, you'd written about it, concerns about accountability of having this period of time after an election before a new administration comes in where regulators are less likely to be accountable because their boss doesn't have to stand for re-election again and so on. But I've tried to understand why would the Chief of Staff of a president who presumably wants that last chance to put their ideological stamp on government go along? I mean, what was from the Bush administration's perspective, so I guess not yours, why do you think they were willing to make any effort? And you mentioned it had mixed success, but why make any effort at all if it was their last chance to enact their preferred set of policies for at least 4 years? Well,
I think the answer to that is that Josh Bolten, who is the Chief of Staff, is a very principled person. He may have regretted it. Once, he made this decision in April or May, I can't remember now, but so he made that decision in the spring. When looking ahead, it seemed this is the right thing to do. We didn't like coming in and having to decide what to do with all these regulations. We don't want to do that to the next president. as I say, he may have regretted it afterwards because it was very difficult, and he spent a lot of time on it towards the end, because he was getting calls daily from cabinet members who really felt very strongly that their regulations should get an exception. So,
And perhaps in April, you don't know who the next president's going to be. It's easier behind a veil of ignorance to say, well, you know.
and I think that was part of it. And he also wanted to have the time limit behind that veil of ignorance. So he wanted to have final regulations by November 1st. So regardless of who the next president is, we're not going to saddle him with a lot of regulations that they have to decide what to do. And
All right, other questions?
do you need a mic?
Just on that same point, wasn't the point that he set the deadline so that they'd be final, so that the new administration couldn't do what Bush administration had done, the Clinton era ones, which was to suspend them before they went into effect? It was an effort to actually increase the ability to do midnight regulation by getting them done on time.
And I was the one who recommended that we do it, that we issue the memo. I was in all the conversations with the chief of staff about it. That was never part of the discussion. So, I know that's something that people have been skeptical, have been, but that was never part of his decision. So.
Does it make sense to have the person heading up that agency be a political appointee?
Well, I think that's a really good question. Often it's not, as Jim knows. There's often, because everyone else, OMB is it's a flat agency, and it's mostly career professional staff. So most of my staff, I was actually on the career staff in the 80s. And so when I went back, a lot of my colleagues who I'd been, in fact, my branch chief was still there. So my colleagues who I'd worked with. So that same career staff has a long tenure. And the deputy administrator, who is a career professional, not a political appointee, is the one who is acting administrator when there is no, when the presidential appointment hasn't been confirmed. I think it is important to be a presidential appointee because you're in the White House. And career professional staff, when you're dealing with, you're dealing with the head of the Domestic Policy Council, the head of the National Economic Council, Homeland Security Council. These are all people who are presidential appointees, have the ear of the president. A career professional, no matter how knowledgeable they are, is not going to be able to relate. Relate's not the right word, but they're not going to be able to have the same influence. So the career professionals are essential, and I think it's very important that really the only political person in OIRA is the head of OIRA. So that career staff has that tenure. But I think it is important to have it be a presidential appointee. It was not always Senate confirmed. So OIRA's been around since '81. The position became needed to be Senate confirmed in '86. I can see why it was done, to make it more accountable. I think that the downside is that, as I say, there's no champion for it, and so it languishes. You can't not have a Secretary of Labor or a Treasury Secretary, but who cares about the OIRA administrator? Most people haven't even heard of it. So.
Questions?
I think this guy's first.
This whole thing about paying the agency for the privilege of polluting the air, doesn't this aptly illustrate what the problem is? Because the agencies look good to their constituents. The politicians look good to their constituents, but somehow the environment is still getting messed up, and the government is taking in money. So it seems like everybody is going home happy except the people who want a clean environment.
I mean, there are a lot of different elements of your question. I mean, and one is, do pollution taxes make sense, and do they improve the air quality, which I have personal views on that. Probably doesn't relate too much to the OIRA oversight. I mean, I do think that there need to be checks and balances in the government. I also think that that markets do work pretty well, and one of the problems with markets is that there are externalities, which is pollution in the air, and that there are different ways of addressing those externalities. And those are the kinds of different alternatives that agencies should be looking at when they issue regulations.
Yeah, Brian Mannix, I was at EPA in the midnight period, and I just wanted to say, in response to the gentleman's comment, that while the White House may not have been thinking about the likelihood of being reversed, within the agencies it certainly was a consideration. And it's not just the fact that you might, if you issue a regulation towards the end of an administration, it might get reversed and you have to do it all over again. The career staff, too, were very loath to do things twice, to do it all over again in the next administration. But also the Congressional Review Act. The regulation is always subject to review by Congress, but because they have to vote with both houses and get the signature of the president to veto a regulation, that won't happen under a president who issued the regulation, but it can happen during a transition. And so they're reluctant to put a regulation out in that period where it would be subject to veto by Congress and signature by the subsequent president. So yes, the fear of being overturned is very much a consideration in getting work done early.
If OIRA has no champion, no natural constituency, how effective has it been? How effective can it be?
Well, and I'm glad you said that, because I think the president has to be OIRA's champion. The president has to care about what OIRA says, and not just the president, but I didn't have any small meetings with the president. So it isn't as if OIRA has a direct voice to the president, because I reported to the director of the Office of Management and Budget, and there were two directors during my tenure there, and they both were very supportive of my function, and they were the ones who would tend to talk to the president. So there needs to be that. The champion needs to be the White House itself. They need to value the role and realize that we do need, the president himself cannot get together his different cabinet members whenever there's a dispute over a particular regulation, that you need to have someone else who does that so that the disputes only get to the president when it really can't be resolved another way. So I think that's the champ. It has to be the champion, is the White House itself.
Oh, thanks. Thanks, Susan, for that terrific outline. My question is, what is it exactly that you all are overseeing anymore and coordinating? And here's what I have in mind. When OIRA was founded or funded or established in its present configuration in the early 80s, you dealt with a finite number of agencies with a relatively controllable policy environment. This was before state attorneys general, before mass litigation, before state regulators really felt their oats and, rolled out a whole lot of new regulations on their own, before mass settlements that restructured entire agencies, before the California Air Resources Board really got going and felt good about itself and sort of tried to control the ecosphere. Is it not the case that OIRA really controls or coordinates an ever-diminishing sort of piece of the regulatory landscape that's out there? Even the agencies can no longer control that. And if that analysis is roughly right, I mean, is redoubled effort enough, or should one think about somewhat more fundamental institutional controls that might do some of the same things that OIRA initially could do but no longer can?
I think that's a good intro to Professor Adler's roundtable tomorrow, the regulation through litigation roundtable tomorrow. I probably should have mentioned litigation as one of the constraints to doing good regulatory analysis and ensuring good regulation. There still is a lot to do, but it is often, you're right, what we can do with, what agencies can do with regulations is often very constrained by litigation that has gone before. It doesn't feel that it's a shrinking sphere, although it still feels like a massive amount of work, but I probably should have mentioned litigation as well as legislation, and one of the things that definitely influences regulation, not only the types of regulation, but exactly how it's done.
Just your personal opinion, do you foresee a continued upward trend in the number of regulations or a downward trend given Professor Sunstein's belief in libertarian paternalism set forth in his articles in Nudge?
I still predict an increase in regulatory activity. So there, you still have the legislation, so there's going to be an increase in legislative requirements, and agencies have to act. There's the litigation that will be also driving regulation. I don't foresee a decline in regulation. Short.
Along those same lines, when you were in OIRA and then also kind of predicting forward, did you have a sense that with the really significant economic regulations that might be coming out of agencies that you needed to pick one or two, like that picking your battles was key, or was the office more just doing a push-pull, with every regulation that came along and getting good response from the agencies? And is that another example of where you're going to have a supportive White House to have that relationship?
Well, there definitely is an element of triage because, and I should have these numbers at my, at my statistics at my fingertips, but there are a lot of significant regulations that come through OIRA, and the OIRA staff is about 50 people, but that includes the statisticians, it includes the information policy, it includes the admin. So really what the actual staff that reviews the thousands of regulations each year is probably 30 people. They're 30 great, hardworking people. And so you don't pick just a couple because there's someone who's in charge of the agriculture department and someone else who's in charge of the occupational safety and health and education. And so those people will focus on those regulations. But there definitely is an element of triage because you can't, I do believe they all get read. All the regulations get read. But you can't spend the same amount of time on every one.
So in terms of, you talked a little bit about the importance of being a presidential appointee, be able to weigh in against other folks in the White House, perhaps even agent or department secretaries. In your experience, was the level of support you felt you got in terms, and I know you may or may not, I don't know how comfortable you are answering this question, but I'll try anyway. Did you feel that the degree of support you got within the White House was in part a function of the nature of the issue? That is to say that if you thought a quote-unquote liberal regulation from the Environmental Protection Agency wasn't supported by sufficient analysis, the White House would be supportive. But if you had an equally unsupported Homeland Security regulation that because of the subject matter, the White House was less willing to support pushback or holding the agency to a given standard of analysis and support for its actions?
Yes. And I will elaborate a little bit. The Homeland Security issue, I think part of what I observed there is that say environmental regulation, we had a National Economic Council and a Domestic Policy Council who had broad cross-cutting perspectives. So they had trade-offs in their portfolio. For Homeland Security, we had the Homeland Security Council, which actually had the same perspective as the Department of Homeland Security. So I probably did have more troubles with Homeland Security regulations, I'm sure it's partly because of the perspective of the White House, but I think it is partly the czar. So a czar that has a narrow focus does not provide the same checks and balances as a czar that has a broad focus. So I would bring that back to the concerns that I have about narrow mission appointees in the White House that aren't accountable to others.
And so you would expect that that same dynamic in the case of Homeland Security might actually continue insofar as the internal White House structure is the same?
It may.
Okay, that's interesting. Other questions? We have time for a couple more. Any more questions? Another one right here, okay.
One more.
I took two, so go for it.
Some years ago, a knucklehead tried to board a plane with a bomb in his shoe, and since then, hundreds of millions of people have had to take their shoes off at the airport. Did that go through a cost-benefit analysis?
You know, I don't know.
That was
Because
before-
it was before my time. Certainly a lot of the TSA rules do. So a lot of TSA regulations do. And whether that was a regulation or something else, because something did happen while I was there that did not go through. And I thought, wait a minute, shouldn't I have seen that? But the way they did it, it wasn't considered a significant regulation. I just have to tell a little anecdote, and then she has a question for the mic. But oh, you have the answer. All right. She needs a mic then.
That was not a regulation that was done through what we call a security directive. I work for TSA, and I'm a regulator for TSA. So we did that through a security directive, which we often do in response to intelligence comes out in that case. I think it was probably within, I don't know, a very short period of time. So when intelligence comes up to show that there's a threat, it's a much faster way of reacting to those threats than going through the regulatory process.
Yeah, the regulatory process can be slow. There are definitely hoops to go through.
Just was related on Homeland Security. I mean, in the environmental context, or in health and safety context, we have decades of experience of trying to quantify low probability, high magnitude risks. And whether presumably we're better at it than we used to be. Obviously, there's a lot of controversy and conflict over how good at that we are. Are we anywhere near as good at that in the Homeland Security context? Because I assume it's essentially the same dynamic. The chance of a guy getting on a plane and blowing it up is very small, or crashing a plane into a building is very small, but the right terrorist event could be high magnitude, and it would seem to present some of the same problems in terms of cost-benefit analysis.
I think there are some of the same problems. My niece just came in. Some of the same problems. And she's distracted me. But there are a couple differences. One is that EPA and Department of Transportation, they have huge staffs of economists. Brian headed the huge staff of economists that have been doing this work and so they really have a lot under their belt and a lot of experience. Homeland Security does not have that huge staff. You could probably count the number of economists on one hand, or do I need two hands? But there aren't as many economists. I think the other problem is, but they're definitely improving, is that EPA is not regulating a sentient being. So you can low probability of a chemical, a chemical, but a terrorist can see what you've regulated here and just take his terror somewhere else. And so it just adds another whole dimension that is very hard to do. One of the things that DHS is doing, and I think it's a great way to start to understand it, is to do some break-even analysis. So they can't really look at the benefits and the costs, but they can say, okay, this is how much it's going to cost to do this. What would we have to avoid in order to make this worthwhile? And so it's helping them at least kind of benchmark whether we're doing the right thing by the shoes or not. Yeah.
We have time for one last question. Jim, since his name has been taken in vain a couple times.
Yes. Yeah.
Susan, a procedural question. If you or your agency, when you were in charge, objected to a proposed regulation coming out of one of the agencies, and the agency head, either the assistant secretary or the secretary, deputy secretary, one of the political people wanted to challenge the OIRA perspective, Was there a process, or was there just free-for-all politics at the White House level? How were those disputes mediated?
There's a process laid out in the executive order, in President Clinton's executive order. So it's handled generally at the staff level. It gets raised to me. If it cannot be resolved, if it was not able to be resolved between the OIRA administrator and the agency, then it would go to the president through the chief of staff. One interesting thing, I said that the executive order hadn't been changed between President Clinton and President Bush. It actually had, right, after September 11th. Well, before President Clinton, the process was through the vice president. So the appeals process went through the vice president. After September 11th, I guess Vice President Cheney thought he had other things on his mind. He shifted that to the chief of staff. We used that appeals process once, and it was a very visible appeals, but we used the appeals process and went through the chief of staff to the president, and the president made a decision. Just once. It was, you can read about it, just, Congressman Waxman had hearings on it. Ozone, it was EPA's ozone ambient air quality standard. The secondary, yeah, it was, it did not change the effect of the standard at all. Anybody who wants an earful on it, ask me about that one, but yes. But I won't do that because our time's up.
We'll have to save that for the reception. Immediately following this, on the other side of this wall, please join us for a reception. Susan, we have a little keepsake. This is actually probably contraband here for those of you that are at the university. You know, this is our old logo. So this is a collector's item. In 10 years, it'll probably worth a lot on eBay. But please join me in thanking Susan for.